Good afternoon, everybody, and welcome to this cost update on behalf of Bristol Law Society. For anyone I've not met, I'm Nicholas Lee. I'm a cost lawyer at Paragon Costs, and to either the left or right or above or beneath me, you should see James Wibberley, who I call the cost guru, but I think he's officially counsel at Guildhall Chambers, and he's going to be covering the second part of this presentation. Hopefully you can all hear and see okay. I can see there is already something in the chat box, so well done to whoever's found that. If you do have any questions throughout either of the presentations, then feel free to pop them in the Q&A and we will endeavour to pick them up at the end. I think if you put it into the chat box, it will go public. So if you prefer to keep your questions private, then please pop them in the Q&A. We will send around the slides. This is also being recorded, so both the slides and the recording will be shared with you all afterwards. I believe that is all the housekeeping. As I say, this is on behalf of Bristol Law Society, and I'll be taking the first half, and then James will be doing the second half. And I'm going to apologise in advance because this is all about solicitor and client disputes and liens. It's pretty heavy, slightly depressing stuff, but given the rise in the amount of disputes, I think it's all pretty important stuff, and there's plenty that you absolutely need to know. So apologies in advance if you come away from this rather terrified, but hopefully you'll be terrified and more informed, and you will not fall foul of the mistakes that others have made. So I'm just going to kick off by giving a bit of a general introduction to contentious business agreements, because they are not particularly easy to understand when it's a contentious business agreement or not, and the importance of the difference and what is a non-contentious, etc. So I thought I would start just by giving you the definition according to the Solicitors Act of what a contentious business agreement is. It's defined as an agreement in writing, first of all, so that's the first point to understand. It has to be an agreement that's in writing between solicitor and client in respect of contentious business, so that's the second point to underline. It has to be in relation to contentious business. Quite importantly, in relation to contentious business done or to be done, so it can include work that has already been done, it can have retrospective effect, so that's another point to note. Providing that the solicitor shall be remunerated by a gross sum, i.e. some kind of fixed fee, or by reference to an hourly rate, obviously time spent versus rate, or by salary, which is unusual, or otherwise, so that's pretty vague and open, and whether at a higher or lower rate than what would be otherwise entitled to be remunerated. So that is the definition of a contentious business agreement. Has to be in writing and has to comply with these requirements. Section 61 of the Solicitors Act then sets out the court's jurisdiction to enforce contentious business agreements, and importantly, the difference between non-contentious and contentious business agreements is that you need the court's permission to enforce a contentious business agreement. States that the court can consider whether the agreement is fair or reasonable, and the court, if it considers it's unfair or unreasonable, may set it aside, all of the costs covered by it to be assessed, or make any other suitable order. So this isn't just whether the costs are fair and reasonable, but whether the agreement itself is fair and reasonable. So that is an important feature of a contentious business agreement. So you are probably now all thinking, you what? And I'm going to try and just break this down into simple terms. So you've basically got non-contentious business agreements or contentious business agreements. And I've shortened these into NCBAs or CBAs. So, but you can also have a contentious business retainer that's not a contentious business agreement. And I hope you're still bearing with me here. So you can have a retainer for contentious business that is not a contentious business agreement. So by that, what I'm saying is CBA doesn't necessarily have to. Every contentious retainer is not always a CBA. As I've said already, permission is required by the court to enforce any CBA. A CBA must not give the solicitor an interest in the proceedings. However, it can be a CFA. So get your head around that, because of course a CFA does give the solicitor an interest in the proceedings, but a CFA is by its nature a contentious business agreement because it relates to contentious business. So a CFA is a CBA. However, unless it says it's not, and I'm going to come back to a case where the court had to consider whether a CFA that said it wasn't a CBA was a CBA or not. So hopefully you're all still following this, probably thinking, what on earth is Nick going on about? I'm going to conclude this by saying it's definitely a CBA if it says it's a CBA. It's definitely not a CBA if it says it's not a CBA. But if it doesn't say anything, it's certainly uncertain. And I stole that from James when we spoke yesterday, when we were trying to work out where it falls, if it's between the gaps, and the only thing that's certain is uncertainty. So hopefully you understand a little bit about CBAs in that has to relate to contentious business, has to be in writing, you need the court's permission, but if an agreement for contentious business expressly says it's not a CBA, then it's not a CBA. So let's look at this in practice and some examples. And the reason we're really bringing this to your attention is because of the rise in disputes in this regard. A case that I'm going to refer to is W.H. Lawrence, because I don't try and pronounce the claimant's name. This was a case where the solicitors were acting under a fixed fee arrangement. So most of you will be thinking, surely there can be no challenging a fixed fee arrangement. Everyone signs up to it. They all know what they're signing up to. Surely that's always going to be enforceable. Well, client willingly entered into a CBA in this case, providing for a fixed fee of £250,000 plus VAT and disbursements. Now, this was intended to cover both an appeal, which was pending, where permission was being sought, but also unpaid fees. So the client had unpaid fees, and the solicitor said, well, I'll tell you what, we'll mop all this up into one fixed fee, £250,000 for everything you owe me and everything I'm going to do in relation to the appeal. And the client later challenged this. And the court had to consider, first of all, as I described earlier, section 61, was the agreement fair and reasonable? And the court concluded this is a two-stage test. You should look at the two independently. You should first consider reasonableness and secondly consider fairness. And therefore you should almost put aside fairness when considering reasonableness because they are separate tests. What the court concluded in this particular case was that having regard to the work to be done and the disadvantageous terms to the client, the agreement was unfair. Or unreasonable, sorry. It was unreasonable because it covered far more work than needed, or covered far more in fees than what would have been chargeable on a time basis. Of course, permission could have been denied, which would have meant a significant uplift at that stage. So having regard to all the factors, the court basically concluded that the fixed fee was excessive. And because it was excessive, it was unreasonable. Now, in the alternative, the court had to consider fairness. And the court said it was unfair for a number of reasons. First of all, the claimant had insufficient time to consider the reasonableness of the terms and take legal advice. I think there was something like a week in between having these discussions around the retainer and the requirement to file either permission to appeal or notice to appeal, one or the other. So in other words, the client was under pressure and didn't really have time to take legal advice and was pretty much, in their words, backed into a corner. Of course, they had all the unpaid fees to contend with as well. The court said that the proposal, the fixed fee proposal, created an unusual incentive or reward if permission to appeal was refused, because the solicitor would still get the full £250,000 if it all ended in permission to appeal, as they would if it went all the way to an appeal. So they were incentivized to lose, if you like. And there was no advice as to the recoverability of costs in a litigation. And this is the informed consent argument that's happening in the background. Was the client told, I'm going to be charging you a fixed fee of £250,000, but in fact, my time on the clock may only be £20,000, and that may be the most you will recover from the other side. They weren't, and the court said that was part of the unfairness in the agreement. The court then concluded, and you'll remember my section 61 slide that said that the court could set it aside, they could assess it or do what they want. Well, the court concluded in this particular case, it couldn't be assessed. There were no rates or no fallback provisions. It couldn't be assessed or reduced. And therefore, the court felt that the only option was to set aside the entire agreement, £250,000 gone, purely because it was unfair and unreasonable. And I'm sure that the solicitors in this case felt particularly aggrieved, and I'm not sure where that leaves them in relation to the unpaid fees that existed before this arrangement was put in place. But I should imagine there's a very significant loss to the solicitor. The agreement was found to have been unfair and unreasonable. The flip side of this is there has been a case where a contentious business agreement well, in fact, would have been upheld was it a contentious business agreement. And this is the case of AccuPay. This was a case where the claimant entered into a CFA with the defendant. The claimant argued that the CFA, first of all, was a contentious business agreement, but they said it was void for want of consideration, that the definition of success was unfair and unreasonable. They weren't advised to get legal advice, and they weren't advised as to the likely costs of litigation, etc. When you read this judgment, if you have time to read it, you'll see there was a long list of reasons why the claimant said that this CBA was unfair and unreasonable. However, the court upheld the agreement. They said there was sufficient consideration and the solicitor wasn't advised to tell the client every possible means of funding the case, in particular those that they weren't even prepared to offer, because that was one of the complaints. The court held that the definition of success was reasonable. The client had been told it could take independent legal advice, but in any event, the court said, well, the client's been fully and properly advised, so there would be no reason for them to have to go and get independent legal advice, but in any event, they were told that they could if they wished to do so. They said that the CFA was balanced with advantages and disadvantages to both parties. So I think that fairness piece was quite critical. The court said this was a fair agreement. Solicitors did as much as they could to reasonably forecast costs, and all of you will know that it is very difficult to forecast costs, particularly at the outset, but of course your obligation is to give the best possible information and to update the client as and when you can, or as and when the requirement for an update exists. But the solicitors did as much as they could. So the court said if it was a contentious business agreement, it was a fair one and a reasonable one. So it met the criteria and it wouldn't be set aside. But the court went on to say that section 59, which I described earlier, was permissive and not prescriptive. Therefore, it permits a contentious business agreement, but it wasn't prescriptive. So if a CFA says it's not a CBA, then it's not a CBA. And in particular, this CFA said it wasn't a contentious business agreement. I have seen that in a number of CFAs. Therefore, it's not a contentious business agreement, and it's a straightforward case of enforcing a contract, a contentious retainer that is not a CBA and is not a non-contentious business agreement. It is just a contract to undertake the work, and it won't fall subject to the contentious business rules that I described earlier. So there's the bad and the good. In this case, the court said it was fair and reasonable, and it wasn't this CFA wasn't a CBA, but in the fixed fee case, the court took a very harsh view of setting aside the entire agreement. And of course, the court could have said, well, what I'm going to do is give you a fair sum for that fixed fee. But the court felt that they had no choice but to disallow the entire thing, which I think was particularly harsh. Terminating the CFA, and this is particularly important, I think, for you to understand, first of all, whether you're entitled to terminate a CFA, and certainly that's something that James and I are instructed to advise upon at the moment, whether a CFA was properly terminated, and if you do, what are the obligations, responsibilities and liabilities. So in this case, the claimant was the law firm. They terminated the CFA after limitation period expired because the client hadn't given them instructions to issue. Limitation passed, therefore there was no prospect of the claim succeeding, and the law firm terminated the CFA. And the law firm argued that the client hadn't kept their responsibilities under the CFA, they'd failed to give instructions to issue proceedings, and therefore under the terms of the CFA, they were entitled to charge the client basic charges and disbursements. Of course, you can't charge the success fee because the claim hasn't won, but if a solicitor terminates the CFA because a client hasn't kept their responsibilities, then ordinarily the solicitors can charge their basic charges and disbursements, but again, that's subject to whatever wording is in the CFA. So that was the basis upon which the solicitors said they were entitled to be paid. Now, the court held, actually, that the solicitors were at fault for the limitation period having expired. They said that they had failed to advise the client promptly and properly, and therefore gave the client insufficient time in which to give them instructions to issue proceedings. So in fact, they pinned the blame for limitation having expired on the solicitors, and they therefore said that the client wasn't in breach of the CFA and had kept their responsibilities. Therefore, they couldn't terminate the CFA, and the claim for professional charges was dismissed. So as I said at the outset, the lesson to be learned from this case is to understand who is terminating the CFA, why they're terminating the CFA, are they entitled to terminate the CFA, and what are the consequences. Too often, I think people use these CFAs and get clients to sign up without fully appreciating and understanding what it is they're signing up to. Perhaps it's a firm template and everyone assumes it's right. Well, that's all well and good, but if you need to terminate because a client's not giving you instructions, isn't accepting your advice, you need to fully understand what your rights are under that CFA. So again, a pretty important lesson to understand. Takes me on to Belsner and the issue of informed consent. And I'm not going to take you through Belsner in great detail because it's been well reported, and most of you will know this is heading off to the Court of Appeal, and your eyes may water when you learn that the costs arguing over this £385.50 are said to be around £87,000. £87,000 arguing over £385.50. Anyway, Belsner, what is the situation? Well, in Belsner, of course, the court considered section 74 of the Solicitors Act, which said that the amount allowed on a solicitor and client assessment cannot exceed that which would have been allowed as between party and party. So in other words, you can't recover more from your client than you would be able to recover from a third party. However, CPR 46.92 says that this can be overridden by written agreement, and most of your client care letters will say we are entitled to charge you more than we can recover from another party. So you have contracted out of section 74, which is permitted by 46.92. The question that was considered in Belsner was whether contracting out of it required informed consent, i.e. do you have to tell a client precisely what they're likely to recover and not recover to enable them to give informed consideration to whether they want to enter into that agreement. At first instance, District Judge Bellamy held that the client care letter contains sufficient information, is what I would describe as the usual client care letters. But Mr. Justice Lavender disagreed, said that an explanation should have been provided as to the likely amount of unrecoverable costs. The client could have then asked for a cap or whatever else, and therefore they must give informed consent to deduct unrecovered costs from damages. They have to know from the outset, for example, our costs are likely to be £10,000, you're likely to be able to recover £6,000, the difference of £4,000 will be payable from your damages, and then the client could say, oh, feels a bit heavy, any chance you could apply a cap of £2,000, or can we take a view on it, or whatever else. But you need to give the client an educated, informed illustration, if you like, that enables them to give informed consent, so say Mr. Justice Lavender. And I suspect that the concern amongst most the legal profession is the client care letters generally or historically haven't given that much information. So what does that mean for solicitor and clients, not just in the case of PI cases, but in any case where they haven't given informed consent and haven't given sufficient information at the outset as to what's likely to be recoverable? What does that mean? So there are wider implications, and as I understand it, I don't know a date, but this is off to the Court of Appeal. So this is the Belsner point of informed consent, and really starts the string of a number of worrying cases. I did warn you that this was slightly depressing, and I'm sorry about that, but I'm hopeful that by learning this, you will all go away and look at your retainers and make sure they don't fall foul. This is a case that I'm going to call Ratcliffe Solicitors. This was before Master Court and SCCO, who is the senior cost judge in the SCCO, so he carries some weight. And what he had to consider was whether the invoices that had been rendered throughout the litigation were statute bills. And he concluded by saying that regardless of whether the bills appear to be statute and are compliant in themselves, the retainer has to state if invoices are intended to be final statute bills. So if the retainer doesn't expressly state that the invoices will be statute bills, then they're not. The client care letter in this particular case said the firm would bill monthly, the usual provisions you have to pay, etc., but didn't expressly state that the invoices would be final bills for the period they covered. So all 14 bills that have been rendered during the course of these proceedings, the solicitors had rendered to their client, were capable of assessment, and they only became statute bills when the final bill was delivered, what's known as a Chamberlain bill. And therefore the client had a right to challenge every invoice. And this is important because, of course, if they were statute invoices and more than a year's passed, the client has no right to challenge those invoices if more than a year has passed since they've been paid. And of course, this is 14 bills. So let's say this might be 14 bills over 14 months, but let's just imagine for a moment that invoices have been rendered over the course of a 5-year litigation. and those client care letters didn't permit statute bills, what that would effectively mean is that only when the final bill was rendered do those invoices become statute, and the client's right to an assessment starts from then, and they could seek an assessment of 5 years worth of billing. And of course, over the course of those 5 years, you would have paid the VAT on those invoices and paid your staff and overheads, and then the client at a later date is going to say, actually, I want all of these assessed and they should be a much lower amount. This is a worrying decision. And for anyone thinking, well, perhaps Master Gordon Saker was just having a funny 5 minutes and surely this is wrong, Master Riley reached the same conclusion in a case of Masters and Charles Fussell, again concluding that despite the format of the invoices or anything else, the retainer simply didn't permit statute bills. Said that invoices must be self-contained and sufficiently detailed, as we know, but that the retainer must make it clear statute bills are being issued. He went a step further than Master Gordon Saker. He said that you should explain there are time limits for seeking assessment, what they are, the process, and the consequences of not doing so, all within the client care letter. Now, many of your invoices might say you've got a right to an assessment under the Solicitors Act, but very few client care letters or bills go on to say how you seek an assessment, the process, and the consequence, i.e. if you pay this bill and more than 12 months passes, you won't have a right to seek that assessment. So this is worrying. Now, one aspect of this I certainly agree with is that in this particular case, the solicitors were acting under a discounted CFA. And the court said, well, you can't interim bill under a discounted CFA, and that's got to be right. There can't be statute bills under a discounted CFA because the nature of a CFA is that the final fee is not known until the outcome is known because it's conditional upon the outcome. So those invoices can't be statute bills. That makes sense. So I agree with that. But I have to say, I was rather surprised at both masters saying that this much information is required in a client care letter. And it continues this theme, this trend of obliging solicitors to give a lot more information than they are currently or have done currently. I say that flippantly insofar as I've seen most client care letters. I'm sure this doesn't apply to you or your firm and all of yours are perfect, but it applies to everybody else's. And what about these common law assessments? So quite often we have situations where clients are being billed monthly. Maybe the retainers permit interim statute bills, but the clients have let the payment of those invoices drift. And you think to yourself, well, yes, we've got 2 years worth of unpaid invoices, but over a year's passed, so surely they can't challenge those invoices, can they? Well, no, they can't under the Solicitors Act. If more than a year's passed, the court won't order an assessment. But if the invoices are unpaid and your firm sue for those unpaid invoices, then the client can ask for a common law assessment as part of that enforcement process. They can't ask for a Solicitor Act assessment, but they can say as part of their defence, well, these costs are unreasonable, and the court can order a common law assessment. So that's another way around for clients wanting to seek an assessment of your costs where they would otherwise be deprived of doing so under the Solicitors Act. Now, because it's not a Solicitors Act assessment, the usual 20% rule doesn't apply. For anyone that doesn't know, if a solicitor challenges, if the client challenges the bills under a Solicitor Act, they have to reduce the bills by more than 20% or they'll pay the costs. Of course, that wouldn't apply on a common law assessment. It would effectively be the usual rule, I should imagine, that the receiving party will get their costs unless the paying party makes an offer that the receiving party fails to beat. So it's a slightly different procedure. What is the solution to this? Well, get paid up front. If you are paid up front, you raise your invoice, it has been paid, it's a permissible statute bill under your retainer, and a year has passed, your client doesn't have a right to an assessment. They won't be able to apply under the Solicitors Act. You won't need to enforce it, so they can't apply for a common law assessment. So if the bill's paid, that will be the end of the road. I know it's not the perfect solution, but to my mind seems to need to be the only solution. Of course, you probably shouldn't let your client's bills go so long unpaid in any event. So common law assessment, something that's not readily known about, but they do exist. Why the rise? As I say, the days of your pay nothing have gone. The CFA, will only get what we recover. They seem to have gone. Most firms are now charging clients monthly or charging clients for the shortfall because they have to. Success fees no longer compensate for unrecovered costs. Cost recoveries are getting tougher because of proportionality and cost management, so clients are ending up having to pay more. I think clients are now more aware of their ability to challenge your fees. There are companies out there who shall remain nameless, but they're doing very well out of encouraging clients to have a go. And clients can't be expected to interpret the wording or understand the law. It's your duty as solicitors to make sure that everything is carefully explained in plain English to someone that would understand it, who is not sophisticated in dealing with litigation. So my advice is that it's time for a health check on your client care letters, your terms of business, your CFAs and invoices. Ensure that you are permitted to raise statute invoices if that's what you intend, or ensure that clients are given that extra bit of advice as to unrecovered costs and an illustration of what that looks like in the litigation to start taking that step towards what informed consent actually looks like. This isn't, of course, only relevant for you and your client. If ever you're taking over a case from a firm, and the client's unhappy, or if you deal with professional negligence and again the client is unhappy with the fees charged by your predecessor, this should be food for thought. You want to ask yourself, well, how were you billed? Were you billed in the right way? And is there something we can now do to challenge the fees that have been charged to you? So hopefully this presentation gives you the ammunition to do so. That is the end from me, with a couple of minutes to spare. So I think I'm going to hand over to James now, who, as I said, is the cost guru, counsel, Guildhall Chambers. And if there's an answer I don't know, he tends to be the man I go to. Hopefully you've all enjoyed that, and I'm just going to mute myself. Thank you.
Thank you, Nick. I am probably going to be doing this presentation in the style of Boris Johnson or Professor Whitty, having to ask Claire to click on the slides for me. No, I have just regained control, or just gained control of the slides, so I should be able to control them on the way through the presentation. As Nick says, the golden rule really is get paid up front where you can. So I suppose my section of the talk might be entitled, well, what should you do if you can't get paid up front? Most usually that, of course, is because your client does not have the money to pay you. What are the ways in which you can get your client or their opponent to show you the money, so that you can ensure that if you do have an enforceable retainer, whether it's a contentious business agreement or not, you're actually able to secure payment at the end of the case? I'm going to start, if I can, with an apology to those of you who were at the Southwest Cost Seminar in I think it was May 2018, when I spoke about solicitors' liens. Now, the focus of that talk was very much on what are called equitable liens, and that was because of the way in which the case law was developing at that point in time, with a particular focus on equity's ability to interfere to protect a solicitor's right to payment. More recently, there have been some developments on from that, and the focus of the recent litigation seems to be more in the field of statutory liens, which, as we'll come on to see, are potentially a much broader and more powerful tool in the solicitor's armoury. So the focus of this talk is going to be very different from the talk that I gave in 2018. I start this talk, though, in the same way that I started the talk in 2018, and that is by emphasising the underlying public policy in all of these cases. Solicitors are afforded a great degree of protection by the courts, not because lawyers do favours to other lawyers, but because it is seen as a way of preserving access to justice. There is a strong public interest in ensuring that litigants who cannot fund cases themselves are able to obtain representation. And there is an acceptance amongst the judiciary at all stages that if solicitors can be, for want of a better word, shafted, having successfully represented a client, then that is going to hurt everyone else going forwards. I've just had a message from Jessica to say I'm frozen on the screen. I'm going to continue, but I'm hoping that no one else has a similar problem. If I move on to the next slide, then hopefully this slide is coming up, and if there are any problems, someone can let me know. There we are. I've had a few messages saying that things seem to be working. So moving on then to the different types of lien that we have. There are, broadly speaking, three different types of lien: the common law lien, the equitable lien, and the statutory lien. The common law lien will hopefully be familiar to all of you. It is the right to hold on to money or property as security for payment of a debt that you are owed. In simple terms, you've got two types of common law lien. You have the general lien and the particular lien. The particular lien is the type of lien that, for example, the garage can exercise over your car. If you take your car in to get fixed and then don't pay the bill, the garage can hold on to your car until you've paid for those repairs. But the garage is only able to hold your car for the purpose of securing payment for those repairs. It can't hold the car for any other purpose. A general lien, in contrast, can be used to secure payment of any debt that is owed for any reason. And as a matter of custom and practice, and normally as a matter of contract, solicitors have a general lien. So you are able to hold client property to secure any money that you are owed by the client. The only gloss on that is it is any money that you are owed qua solicitor. If you are also acting in another capacity, then your lien isn't going to help you. So the common law lien then is fairly straightforward, but of course the starting point for common law lien is that you have money or property in your hands. Where the equitable lien and the statutory lien come in is where you don't have any money or property in your hands, and therefore there's nothing that you can hold on to. Now, the first way in which the courts try to remedy that situation is, as I say, through the concept of an equitable lien, which isn't really a lien per se, but is more a recognition that the court has an equitable jurisdiction to interfere in cases to allow effectively a solicitor to be able to exercise a common law lien by controlling the payment of money. Now, that can be done either proactively, with a court preventing a payment being made by the paying party directly to your lay client, or by the court mandating that a payment made by or to be made by the paying party is paid to you rather than your lay client. Or in extreme cases, the court can actually order the paying party to pay for a second time so that the money goes to you rather than the lay client. Or rather, so the money goes to you as well as the lay client, so you can exercise a lien over it. And it's these third possibilities that's really given rise to most of the litigation, starting most notably by a case called Carnes Solicitors and Chifuntway. Now, Carnes is a fairly unusual case, but we can all see similar circumstances arising. So in Carnes, Mr. Chifuntway brought a successful judicial review claim against the Home Office and was awarded his costs. Carnes are in the process of negotiating those costs with the Home Office when they are disinstructed by Mr. Chifuntway. Mr. Chifuntway then says to the Home Office, "You've offered me £13,000 or so for my costs. I'll take that offer, please pay it to me direct." Carnes wrote to the Home Office to say, "No, don't pay him, you need to pay us," which for some bizarre reason the Home Office ignored, and they paid Mr. Chifuntway. As perhaps seemed inevitable, he then disappeared, leaving Carnes with no one to sue for their money. So what Carnes did was to sue the Home Office effectively for a double payment. They said that equity was able to intervene in those circumstances to order the Home Office to pay for a second time, so there was something that they could seek to enforce their lien against. And that claim was ultimately successful before the Court of Appeal, who held that in circumstances where there's either collusion between the parties to defeat a solicitor's lien, or where the paying party is on notice of that lien and makes a payment notwithstanding that notice, they can be ordered to pay for a second time. So in this case, because Carnes had said to the Home Office that payment should be made to them direct because they were owed money, the Home Office had to pay the £13,000 over for a second time. The only slight gloss just to add on that is the £13,000 was all the Home Office could be ordered to pay for a second time, because Mr. Chifuntway had still had capacity to settle the claim for an amount that he saw fit. So Carnes couldn't put themselves in a better position in terms of how much money was payable, but the amount of money payable having been set, equity could order a double payment if the money hadn't been paid where it should have been paid, to enable Khans to exercise their lien. The Khan's principle was then taken one stage further in a case called Gavin Edmondson Solicitors and Haven Insurance, a case involving about £13,000 that went up to the Supreme Court in 2018. In the Edmondson case, Edmondson had been representing a number of PI claimants who had intimated claims through the MOJ portal for fairly low value whiplash injuries. When Haven had had the claim notification forms in through the portal, they'd written to the individual claimants direct, offering them costs inclusive settlements. The individual claimants had accepted those settlements, then just disappeared into the sunset. That left Edmondson unpaid. Edmondson could have gone after the individual claimants, but what they did instead was to sue Haven, and they intimated various claims against Haven, but one of which was a Khan Solicitors and Chaffuntway equitable interference claim, saying that because Haven was on notice that Edmondson had a claim over any recoveries to secure payment, Haven should be ordered to pay for a second time, so Edmondson was able to levy its charges. Now, that argument was ultimately accepted by the Supreme Court, who said that simply receiving the claims notification forms in which Edmondson informed Haven that it was acting under a CFA was sufficient to constitute notice in those circumstances. To a certain extent, I suppose you can see how that's an obvious conclusion. If you are told that your opponent is on a CFA, you know that the opponent does not have the funds to put their solicitors in funds during the course of the case. You know the solicitor is going to be relying upon a lien over any recoveries. You know that if you pay the other party direct, that's going to interfere with the solicitor's ability to exercise a lien. Therefore, in those circumstances, you are at risk of being ordered to pay for a second time. So I suppose before we even move on from the Edmondson case, I'd say to all of you, before you make any payment, if there is any suggestion that you should be paying anyone other than the solicitors on the other side, check and double check that the solicitors are content for you to do that. Now, Edmondson was followed fairly quickly by a decision in Bott & Co Solicitors v Ryanair, with fairly similar factual circumstances, albeit there, rather than being low-value personal injury claims, they were claims for compensation as a result of flight delays. Now, these claims you start by submitting effectively a claim form, but it's a slightly different, less formal claim process than the claim notification form under the protocol for low-value personal injuries. When Ryanair settled off the claimants' cases in the Bott case directly, Bott's argument that it should be paid was successfully defeated by Ryanair on the basis that Bott hadn't actually provided litigation services. So a point of distinction was drawn with the Edmondson case between submitting a claim notification form under the MOJ protocol, which was seen to be the provision of a litigation service, and intimating a claim under the protocol that exists for flight delays, which was held not to be a litigation service. It's a fairly narrow distinction, and perhaps because of that, Bott have successfully obtained permission to appeal from the Supreme Court. But as the law presently stands, you're at risk if you're in an Edmondson-style situation where there's a formal intimation of a claim with notice of a CFA, but you may be okay if there is simply some sort of fairly formulaic process followed that does not necessarily follow in litigation. Now that brings me thirdly and finally to the statutory lien, and it's here I want to focus most of our attention today, because it's here where we've had some of the most interesting recent cases. I've put the text of section 73 of the Solicitors Act up on the slide, and I don't intend to read it out, simply to highlight that in any case, at its conclusion, you have the ability to apply for a charge over any recoveries or assets preserved as a result of your actions. So you can go to court and say, not simply, well, there is a judgment in my client's favour that I would like a charge over, But if you have a case where property is contested or ownership of property is contested and your client has retained ownership to that property, you can potentially get a charge over the property itself. The reason this is so important, or potentially so important, is not just because you can look at preservation as well as recoveries. And of course, in an equitable liens context, you're only looking at recoveries and the ability to get a charge or have the court make an order in respect of money to be paid. But because under the statutory lien, you're effectively leapfrogging other creditors. So the money to be paid, if you get an order under Section 73, will be paid subject to your charge. So you will get first dibs before any other creditor will. So that can be hugely important in an insolvency situation where the last thing you want is for the money to become part of someone's general pot of assets, and therefore you, like everyone else, are just looking for a few pence in the pound. Now, as with the Edmondson case, the case law has really been driven by a single determined individual. In this case, it's the man up on the slide, Ashcan Candy of Candy Solicitors, who were a boutique litigation firm in the City of London. Candy have been involved in a series of high-profile decisions stemming from the liquidation of the Peak Hotels and Resorts Group. And it may be that on your Lawtel or Lexis or Westlaw updates, you will have seen their name popping up from time to time because they've been involved in at least 3 Court of Appeal decisions and 4 or 5 High Court decisions in the past 2 or 3 years alone. Now, the background to a lot of this litigation, as I say, is the Peak Hotels and Resorts Limited liquidation, or first of all litigation and then liquidation. So Candy acted for Peak. Peak were in financial trouble, so Candy said, well, you can't pay us on a normal basis, so why don't we enter into a contentious business agreement for a fixed fee? And I think the fixed fee was in the region of £3.86 million, a fixed fee that is going to be payable on the conclusion of the litigation, but which, because of your financial position, you are going to give a security for. And Candy required Peak to enter into a rather extreme, for want of a better description, series of charges. So Peak gave fixed and floating charges over all of its assets, all of its undertakings, any future recoveries. So any possible asset it had was, on the strict wording of the charge, going to be held for the benefit of Candy and payment of this £3.86 million fixed fee. That happens shortly before Peak go into liquidation. When Peak go into liquidation, the liquidators come in and the first thing they say is, we don't want to continue with this litigation, we want to get out of it. And so Candy are instructed to accept a settlement for about, I think it was £14 million. Of course, Candy do that. And then the settlement having been reached for £14 million, Candy say, well, of course, we're entitled to the first nearly £4 million of that under the terms of our contentious business agreement. What follows then is a series of disputes between Candy and the liquidators as to who gets first dibs on various pots of money. Candy saying that everything is caught by one charge or lien or another, and the liquidators seeking to put as much as possible into the general pot and to relegate Candy to simply one of the general creditors of the company. Now, as I say, there were a series of Court of Appeal decisions over 2 or 3 years, each of these stemming from an earlier decision of the High Court. I'll run through them fairly quickly because the first 2 aren't really relevant to the question of liens. First of all, there was a question of whether Candy was able to charge sums in court, and the answer to that was yes. If a litigant pays sums into court, even though the sums are in court, they remain a litigant's assets. The litigant is therefore able to charge those sums as they would any other asset. The only gloss, and the significance of this becomes obvious in a second, is that Candy was held to have a floating charge rather than a fixed charge over the funds in court. The second Court of Appeal decision involved a challenge to the nature of that charge. And this is an insolvency point, but it's relevant in the context of the costs of acting for an insolvent party. there is a provision at section 245 of the Insolvency Act, which says that during the relevant period, so within a certain period before or after a party experiences an insolvency event, if they enter into a floating charge, that charge is only enforceable to the extent of the value of the goods or services provided at the point the charge is entered or subsequently. The public policy rationale underlying that's fairly clear. It's about stopping companies that are going under from suddenly charging all of their assets, for example, to directors, to creditors, to interested parties, and therefore taking them outside of the pot that would benefit the general creditor class. And you can see why the liquidators went after the charges in this case, because Candy was saying they had a charge over £12 million to satisfy the money owed to them, whereas the liquidators were saying, well, hang on a second, you've done nominal work after that charging agreement was entered into, because you entered into the charge just before liquidation and settled just after liquidation. You've not done best part of £4 million worth of work. Why should you get first dibs on £4 million? And ultimately, the Court of Appeal agreed with the liquidators and said that where you've got a floating charge like this, even though the solicitors have got a contentious business agreement that entitles them to fixed cost remuneration, they can only enforce their charge on a value of service or value of services assessed on a time cost basis. So although Candy still had the charge over the money in court, it could only be used insofar as Candy could prove its time costs between the point the charge was entered into and the end of the case. So we're talking about tens of thousands of pounds being payable under the charge or secured by the charge, rather than the best part of £4 million. And as I say, it's not a strict cost point, but if you're ever acting for a party who is or may become insolvent and you are considering taking a floating charge, that is something that you have to look at very carefully. What is the basis of our retainer? And could it be said that the payment we are seeking to secure exceeds the value of the services provided? Now, because Candy lost in Court of Appeal 2, or rather they lost that point at first instance before it was pursued on appeal, they applied under section 73 for a statutory lien over the recoveries. Because there's £14 million coming in, section 73 says that they are entitled to apply for a lien over it. The liquidators sought to defeat this by running a waiver argument and by arguing that where a party seeks to take further or additional security that is inconsistent with a basic solicitor's lien, there is an inference to be drawn that the solicitor is intending to waive their lien, therefore losing the right to apply under section 73. And the argument here was effectively one that used the Gavin Edmondson line of jurisprudence to kind of, I suppose, work with section 73 to say that a solicitor would have an equitable interest in the recoveries as soon as there's a fund in sight, as soon as there's a settlement. But if the solicitor has done something that is inconsistent with the existence or continuance of that equitable right, they would be deemed to have waived it, in which case they could only fall back on their later security. And again, the liquidators were successful on this point, with the Court of Appeal holding that there was an inconsistency between what would have been Candy's equitable rights, which would have been to go for a charge straight after the recoveries, and the rights under the charge that Peak had executed, under which there was a floating charge over exactly the same asset. And the Court of Appeal basically said, well, you've asked Peak to sign a series of charges which give a floating charge over recoveries in litigation. You already, or would have under your equitable lien, a charge or the ability to seek a charge over the recoveries. There would be no point in you seeking a floating charge if you're intending to rely upon your equitable charge. Therefore, the inference to be drawn from the floating charge is that you're intending to give up your equitable interests or your equitable lien. Therefore, the floating charge is all that you can rely upon. So actually, by seeking to give themselves a greater degree of protection, Candy actually shot themselves in the foot and ended up with less protection than they would otherwise have had. What's also quite interesting about the decision is that the mainstay of Candy's case was that they had told Peak that it needed to seek independent legal advice on the effect of the charges. So they said, well, look, we've got fully informed consent here, or more than fully informed consent. We have a client who has had legal advice on the effect of the funding arrangement. And the Court of Appeal said that doesn't matter, because although the client can be advised on the legal effect of the funding arrangement, they do not know what your intention is. And because you owe them a fiduciary duty, you have to be clear about what your intention is. So you need to spell out as expressly as possible if you are intending to preserve your equitable lien in addition to any other security over the same assets that you are seeking. And I just emphasize that same assets point, because it doesn't automatically follow that seeking additional security is going to prevent you from exercising an equitable lien. It's where you've got an overlap between the two that lets you draw an inference that because you're going for one type of security, you're likely to be giving up a different type of right. That brings me finally to a second case that Candy have been involved in, litigation involving the Tunstall Group. Dispute between two shareholders, one of whom was represented by Candy. Shareholders on one side bring a derivative claim, on the other side bring an unfair prejudice claim. There was also a claim by two of the shareholders to rescind a transfer agreement to reverse the transfer of shares to Candy's client. Despite the fact that you've got three claims essentially stemming from the same set of circumstances, they are parcelled off. The derivative claim goes to trial first, and Candy's client loses quite spectacularly and is ordered to pay £13 million. After that initial loss, the claim in respect to the shares is settled, so Candy's client is able to retain some of the shares. They give up some, or they reverse the transfer of some, but keep a certain number. What the claimants actually did quite well, though, is having reached that settlement, the next thing that they do is they apply for a charging order in respect of the retained shares. So they say, okay, you've been allowed under this settlement to retain the shares, but you owe the company £13 million because you've lost the derivative claim. Therefore, the company seeks a charging order against the shares in the sum of £13 million. And that charging order is made and then on an interim basis and then made final. And it's at that point Candy think, well, hang on a second, our clients lost the derivative claim, they've retained some shares, but those shares are subject to a final charging order. How on earth are we going to get paid in relation to any of this? And what Candy sought to do was to get a Section 73 charge over the shares that their client has retained, and to use Section 73 to effectively leapfrog the final charging order that the company had retained. And Candy's argument was, and again, this builds on the Edmondson case, that as soon as there is a fund in sight, to use the broad wording of Lord Briggs in Edmondson, which Candy said in this case meant as soon as there was the preservation of property, i.e. as soon as there was the settlement under which Candy was able to retain, Candy's client were able to retain shares, an equitable interest arises. And that equitable interest arises prior to any interest that arises as a result of the charging order. So they said effectively our interest is first in time, ergo we can leapfrog the final charging order that Tunstall has got over the shares. Now, as a matter of first principles, that all works, but the problem Candy had in this case stemmed from the terms of the damages-based agreement and the fact that under the damages-based agreement, there'd not been a recovery, therefore there hadn't been a win, therefore Candy didn't have anything that it could seek payment in respect of. There was a further issue that Mr. Justice Zaccarelli identified, which was it's not simply that there was no trigger for payment under the DBA, but even if there had been a trigger for payment under the DBA, because there hadn't been a recovery, it would not have been obvious to a third party to the receiving party in the litigation, that Candy might have an interest in the shares. And the analogy drawn in this case was the bona fide purchaser for value without notice. So because Tonstrait had not known, or it had not been obvious to Tonstrait that Candy might be seeking to exercise a lien over preserved shares, or to apply for a lien over preserved shares, its charging order was able to take effect prior to the lien. So to a certain extent, you've got a notice question there, but the case illustrates quite neatly how, if you do things in the right way, you can potentially leapfrog a charging order. And so you're not just putting yourself above the general class of creditors, you're actually putting yourself above other secured creditors. But equally, how if it's not obvious that you are going to be seeking to do that, it's not obvious that you are going to have an interest in the proceeds of litigation, then it's likely that you will be unsuccessful. There's a couple of preliminary points that were kind of discussed as part of the judgment. I won't go through them now, save just to highlight two things. The first of which is you may have wrinkles in cases where money has been paid to the order of the court. There is a line of argument which says if money is subject to an order of the court, or the court's order in terms of its release, it ceases to become a litigant's money absolutely. And because it's no longer the litigant's money, it's no longer money that a solicitor can seek a charge against, because a solicitor cannot be put in a better position under Section 73 than the individual litigant would be. So if you're looking at an undertaking over, for example, money paid into court, always look at the terms of the undertaking. The second point it stems from the quote at the bottom of the slide, which is there is a potential abuse of process argument that could have been deployed in this case. And it goes basically that if a solicitor knows that the other side are applying for a charge over an asset, then it's potentially abusive for them to wait for that charge to be granted and then turn around and apply under Section 73. Really, the onus is as soon as you know that there might be a claim over that asset or an attempt to obtain a charge under the Charging Orders Act over that asset, if you're going to apply under Section 73, you need to pull your finger out and do it. So where does that take us then? To a certain extent, full circle, if you can seek payment up front, seek payment up front. If you can't, though, there are various remedies open to you, and these are remedies that can even be taken after money has already been paid. In fact, you may have cases where you are the first solicitors acting, and then another firm is instructed. In an ideal world, you'll seek an undertaking from firm 2 to reserve your lien, but even if you don't get that, if you give sufficient notice to the paying party or potential paying party to the litigation that you have an interest in any recoveries, you should be protected, even if there is some sort of mistake that is made by the second firm, or some sort of devious action by the claimant at the end of the day. The key message in all of this is, though, act quickly, give notice, make sure the other side know the basis upon which you are acting and that you are going to be asserting an interest in the recoveries or property that is the subject of the litigation, because if you don't give that notice, that's when you're most exposed. At that point, I'll say thank you and any questions. And I think Nick has just sent a message in the chat to say that anyone should feel free to pose questions through the Q&A box. And I see we've got a few questions already on both elements of the talk.
Yeah, I'll shall I kick off with those relevant to mine, James? So feel free to chip in, and you can read those relevant to you whilst I read these out. So thank you for those of you that post questions. They're always really helpful, and it's good to have a conversation at the end. So one question is on enforcement of CBAs pursuant to Section 61. Is the court's express permission required before an attempt can be made to enforce, or does the court merely have jurisdiction to make a decision if the matter is referred to court? Well, I don't think the court merely has jurisdiction. I think they're obliged to give you, you're obliged to seek permission if you want to enforce it. So my understanding is that you would seek the permission as part and parcel of enforcing your rights under the CBA. And there, at that point, that's when the court's jurisdiction will consider whether the agreement was, or if there's a challenge to the fairness and reasonableness of that agreement. So I think it just becomes part and parcel. You'll say, I want to enforce the £10,000 I'm owed. The first thing the court will consider is there a challenge to whether that's fair and reasonable? If so, that will be a preliminary issue. If not, then I'll deal secondly with the sum sort. James, that in your understanding as well?
Yeah, I agree. I mean, normally enforcement of CBAs becomes more of an issue where you've got a fixed fee agreement. And in those circumstances, you need to apply to the court to enforce the fixed fee. What one will quite often see is an application to the court for permission to enforce, along with some sort of enforcement action. So it becomes more of an issue in the case of potential insolvency, where you would seek to enforce, and then you would probably seek a charge under Section 73 over a recovery. But as Nick says, you need to apply for permission to enforce. I think in practice, my experience, and Nick, you may disagree, is that this is a point that misses a lot of people by. I've seen a lot of cases that have got a long way down the route where no one's actually picked up the contentious business agreement point, and so no one's raised the question of whether or not an application needs to be made. And it's only more recently that people are actually waking up to this as something that needs to be done.
And then it becomes a side issue as to whether it actually is a contentious business agreement, because very few actually call themselves a contentious business agreement. So it's then interpreting the law, whether it has to be expressly stated or can be implied. And James, I know you've had some experience of that. I've not had that luxury of arguing whether something is or is not a contentious business agreement, but I think you have.
Yeah, and you have the nice point that you articulated, Nick, of whether it's a contentious business agreement or just an agreement for contentious business.
Yeah. We've got a question about can you compare the position on interim statute bills as opposed to final statute bills? And I may have caused some confusion there, because frankly, whether it's an interim or final statute bill is almost academic, because so long as it's a statute bill, you have the right to enforce it, and the client has the right to seek an assessment. What I was trying to emphasize is that if you are trying to submit an interim statute bill, but that your retainer doesn't permit it, then it becomes an interim on account bill, which means that you couldn't sue, and the client's right to an assessment doesn't start until you render the final bill, which is then treated as a final statute bill in circumstances where they were interim on account bills. So that is the difference. Forget whether it's interim or final. The question is it a statute bill or not? And if it's not a statute bill, it will only be a statute bill when you put in your final bill. And it's the point the court are labouring.
Yeah, and I think to a certain extent there's something quite misleading in the traditional terminology of interim statute bills, because as you say, Nick, either it's a statute bill or it's not a statute bill. The only difference between an interim statute bill and a final statute bill is a final statute bill will cover all of the case. An interim statute bill is a final statute bill, but it only covers, for example, a month's worth of work. So the question is this the one single definitive bill in respect of a piece of work or a period of time? If it is, then it's a statute bill. If it's not, then it's not a statute bill, interim or otherwise.
Few questions for you, James. On BOT, is recognisable litigation service to be read as synonymous with reserved legal activities to any extent?
Maybe. It's not the way that the case was dealt with, but it would make sense if that is how you rationalise it. I suppose you can see the public policy rationale for that, which is, well, you should be given protection to solicitors, but not other professionals providing quasi-litigation services. I suppose the only other point might be, and this might be a reason why you would read them slightly differently, is actually solicitors have to a certain extent always had better protection than, for example, counsel has, because counsel's never been able to exercise a lien. So there's always been something particular about solicitors and why they get protection. So it may be that ultimately there is a more nuanced distinction there, albeit, as I say, it would make sense if you rationalised it like that.
Thank you. Another question, does money paid to the order of the court mean the same as money paid into court?
The answer to that is no, because what I meant by money paid to the order of court is you might have a dispute between two parties about where, for example, sale proceeds of property should be distributed to, and you would agree that that money is going to be paid pending agreement or order of the court. So the issue there is not where the money is paid, but the circumstances in which the money can be released. And because you are fettering someone's ability to release the money, you're effectively saying that the court has ultimate control over the money rather than one of the parties. That's when you're effectively taking it out of the scope for consideration for things like charges under Section 73. Of course, money paid into court, money could be paid into court for any number of reasons, and just because it's paid into court, it doesn't mean that necessarily the court retains control over that money. And an obvious example of that might be, for example, a security for cost situation. You might pay money in as a condition of the case not being stayed. That doesn't mean it ceases to be your money. And that was one of the points made, I think, in the first High Court and Court of Appeal decisions in the Peak Holdings case, that Peak had paid 12 or 13 million pounds into court. But because it was into court but not subject to the order of the court, it remained Peak's asset. They had control over it, therefore they had been able to charge it.
Thank you, James. Sorry, I've quite a few of these are for you, James, so I've got one more for you. Do you have any thoughts about whether a subject access request might be used to trump a solicitor's lien over the file of papers?
I would have to double check what you can actually get hold of on a subject access request, because historically, and I've only had this issue arise in relation to the old Data Protection Act rather than under GDPR, actually you can't get as much as you think under data protection legislation. It's more about finding out what personal data about you is being held and what it is being used for, and getting copies of your personal data rather than getting copies of everything. So it's not a means of seeking disclosure per se, if that makes sense.
Interesting, though, isn't it? Because does personal data just include your name, and then by reference, does every attendance note that quotes the client's name constitute personal data that they're entitled to? That would be an interesting dispute, wouldn't it?
Yeah, I mean, as I said, I've had this under the old Act rather than GDPR, and certainly under the old legislation, you could have a series of attendance notes which each have the client's name in, but just because the client's name is in the attendance note, it doesn't give the client a right to the whole attendance note. It gives the client the right to be told that we are using your personal data for the purposes of, for example, recording in attendance notes. But that's all you're entitled to be told. I don't know, as I say, what the GDPR position is. It might be an interesting question.
Thank you. Our top 3 tips for avoiding solicitor and client disputes. I mean, I'm happy to kick off. My first would be, you need to do a health check on all your funding arrangements, your client care letters, your terms of business, your CFAs, just to see whether they can be strengthened to give the client more information, to comply with informed consent, whether they properly explain the billing arrangements, and that's the intention. So you can do this yourself by reference to the law, or you can use people like me and James, and there are a couple of other good cost lawyers and cost barristers if you choose. But I would certainly do a health check of your retainers. That would be my first thought. Second, really back to basics, make sure you're giving the client cost information at the outset and throughout. Don't forget about it. Make sure it's got the usual assumptions and caveats, because that is another area where people fall foul. Thirdly, avoiding solicitor and client disputes. I think it's all about effective communication with your clients. Too often cost is a subject that is forgotten about, invoices go unpaid, and no one wants the embarrassment of saying, well, you know, I'm going to stop acting for you if you don't pay me and everything else. You are running a business. You're not entitled to do that for free. Be confident enough to say, I've got bills to pay, you've got bills to pay, you need to pay yours so I can pay mine, please. and have that open conversation from the outset, and don't wait till 4 years down the line and having to enforce, and then James tells you he's going to ask for a common law assessment, and it all comes to bite you in the bottom because you were being generous with your billing arrangements. James, have you got any other top tips?
I just say that you as a firm need to think about the basis upon which you are billing, because too often monthly invoices will go out in a case without anyone actually thinking, well, are these requests for payment on account? Are they final statute invoices? I've had cases where the invoices go out looking like final statute invoices, and where probably that's the intention at the time, but then they're still, or the firm's still trying to reserve its right to seek increased fees at the end of the case. So you always need to consider what you are doing and make that decision, not just clear in your own mind, but clear to the client throughout the life of the case.
Absolutely. And there is an advantage of not rendering statute bills, which is that if you take a view that, well, I've got £10,000 worth of WIP, but I'll only bill the client 8 because I'm generous like that. If that's not a statute bill, you can change your mind and charge the client the full 10 at a later date if you wish. So there are some pros to the solicitors of not rendering statute bills. But certainly in my experience, I think most lawyers have always intended to file statute invoices because they want the certainty of being paid at the time, and it's just that they've fallen foul of the rules. If there was another tip, by the way, it would be keep on top of case law, because these cases are coming out thick and fast, and what we tell you today could be wrong tomorrow. I've advised on more client care letters and CFAs in the last 6 months than I've done probably in the last 6 years, and I always caveat it by this could be wrong in a week's time because the rules are constantly changing. The examples of retainers needed to explain statute billing, that wasn't in my mind a year ago. I don't think it was in anyone's mind. So that is a new thing that everyone needs to keep on top of. Good question here, and I'm not entirely sure I know the answer to this. So this is where I'm going to look at James. Bearing in mind the issues that have been raised, what are the advantages of using a contentious business agreement as opposed to just having a retainer for, I suppose, contentious work that is expressly not a CBA? What would be the advantages of having a CBA for contentious work? Any thoughts on that, James?
It normally comes in ability to seek judgment quickly for a liquidated sum. So the real advantage of contentious business agreements come where you're under some sort of fixed fee agreement. And if you're under a fixed fee agreement, you can, at the end of the case, very quickly seek permission to enforce and get judgment for a liquidated sum. And the benefit of judgment for a liquidated sum, I suppose, is twofold. Not only is it helpful in terms of things like Section 73 and applying for a charge over recoveries or preserved assets, but if you're actually going against your client, it's often overlooked that you can't just bankrupt a client over unpaid legal fees. You can only bankrupt a client over a liquidated sum. And there's a line of case law that effectively says that before a solicitor can bankrupt a client, the fees need to have been the subject of assessment, judgment, or agreement. So if you are owed £10,000 under a CFA that is not a contentious business agreement, and your client's not paid and you seek to bankrupt them, that will be kicked out because the figure hasn't been fixed. Whereas if you've got a contentious business agreement, you apply to enforce it, you hopefully are able to enforce it, you get your judgment, you have judgment for £10,000, you can then enforce that, as I say, either against the other side or by bankrupting your client. So it gives you that certainty.
So CBAs are frankly more beneficial, specifically where there's a fixed fee arrangement, but I guess less so if it's an arrangement where you're billing by the hour.
Yeah, albeit even in a billing by the hour case, you can seek permission to enforce. I mean, the really clever use of them tends to come in big pieces of commercial litigation where you have insolvent or potentially insolvent client, and you can get your permission to enforce and your fixed judgment, and then you've straight away got something you can seek to enforce. And as I say, in an insolvency situation, you want to be using Section 73 to jump right to the list of creditors and make sure that you've got effectively all of the fixed fee can be secured, as opposed to being in a situation where you've got a longer process of kind of seeking an assessment. And if it takes you several months or a year to seek an assessment, can you actually effectively seek a charge for everything that you might subsequently get on assessment over all of the assets or all of the recoveries, and it becomes more difficult in those cases.
I'm with you. I think we've answered all of the questions, so hopefully you've all enjoyed that. If you have done so, then please feel free to head to the Bristol Law Society website. There are loads of webinars, and there's a huge programme. I don't try and remember them all, but there are lots. Whatever your interest, there'll be something that you should like. Hopefully you've enjoyed that. Feel free to give any feedback to the Law Society as and when you get your slides and the link to this video. And thank you all for listening, and wish you all good afternoon. Thanks, James, for your input. Thank you.